So welcome everyone to Nuts and Bolts Trustee Training for Helpers and Clients. And today we'll be talking about what happens for estate settlement when a client dies. If I can get my computer to work with me. There we go. This is one part of the family education program. There are, of course, 4 parts. The first part was the general introduction, which was last month. That was recorded and is now on the website. We'll be going over how to get to that now. But this program, as well as the other ones, are for both clients and for helpers and beneficiaries. So at some points we'll be talking about specific things for clients, and at other points we'll be talking about specific things that are pertinent to helpers. So what are the client's goals for the program? As far as we understand it, whenever clients come to see us, their primary goal when they're talking to us is to make things smoother and easier for those that follow. So what they want to do is they want to make sure that their estate settlement is smooth, that it's easy, that it isn't full of rocks and problems, and that's one of the primary goals that clients tell us. So to meet that goal, Nuts and Bolts for Clients is designed to familiarize you with the settlement process. For your peace of mind, of course, we want to reinforce your current commitments and to set your proper expectations so that you know what's going to happen, and that way you'll be able to think about it better and understand what you might want to adjust if you think about that, and also to help you evaluate your helpers. Because sometimes things change and helpers change, and you might want to change who specific helpers might be depending on the circumstances in your case. We want to make sure that our clients have a better vision of how their planning actually works out, what actually happens, so that they understand how they're impacting the people that they leave behind. And we want to discuss some concrete steps that our clients can take so that they can make the process better for their loved ones. Now, how about for the helpers? We'd very much like to hear your goals for the program. Remember, this whole idea is that we're trying to make sure that both the clients and the helpers, or in other words, people who play a role in their planning, are fully prepared for things before they happen, so that it isn't a big surprise and very confusing. So we'd love to hear any goals that, if you're a helper, you might have. And so share those with us. Send us a private email. I'll show you how to register on the website in a little while. And of course, by attending this program, you are entitled to the first call program, which means you can call us anytime to ask questions about the planning that your associated client has done. And we're very happy to talk to you. The meter isn't on, and we're not going to bill anybody. So let us know what's working for you and what's not. We also want to familiarize you with the settlement process as a trustee or as a beneficiary of a plan, and to build your confidence in the process, because there is a process that occurs when someone dies for estate settlement purposes, and it's important that you have confidence that that process is going to get the results that you expect. We want to explain your commitments, both ours and yours, and so that you'll know what the proper expectations are. And we want to make sure that you're prepared for the issues that you might likely face, because it's not good to have surprises when someone dies, because it's a difficult process, and having surprises in the legal area is never very helpful. So, and we also want to provide an overview of how things actually operate, what tasks people perform, and how it actually works. And we want to let you know how you can help the client better prepare for estate settlement. So, there are some proactive lifetime steps that our clients can do, and our whole program is designed around the whole idea of being proactive. We have I often said to our clients, and this is something that you helpers should know, that the Step 2 program, which this is all part of, is sort of like doing estate settlement while you're alive. Training the people who are going to be involved about what's supposed to happen, making sure that their documents and the titling of their assets are all up to date, so that everything is all set for them if something untoward happens. So the first thing that is a proactive step that a client can take is to fully fund their trust. And this is one of our primary aims in the Step 2 program. When we do our original client planning with people, that's one of the primary things that we're making sure that we do. We handle all of the funding even after they've done their initial funding as part of the program. So we want to make sure that everything is titled properly and is in line with their instructions in their trust. What we want to do also is to have you communicate the what to do steps now. In other words, communicate with the people who are your helpers some specific things that you might have in mind about what should be done if something happens. So make sure that those steps or those issues are communicated now. Inside your red book, and for you helpers, I want to make sure that you understand what we're talking about when we're talking about the red book. Everybody who has done planning with us has a fairly large set of 13 or 14 documents, and we put all of those documents in a red binder. We call that the red book. And inside that red book, there is a section where there is a location list. So we recommend that all of our clients make sure that they have filled out the location list in the red book. What that is kind of an organizer. It says where everything is, where the key, for example, the key for the safe deposit box is, things like that, where securities are, etc. So that's important to fill out the location list. And one thing that we've been paying a lot more attention to lately over the last couple of years is passwords. One of the major aspects of someone's wealth has to do with all of their electronic assets or property or rights. And so it's important to make sure that the passwords that go to your LinkedIn account or your email account or whatever might be, your bank accounts, etc., are stored somewhere that's safe and secure, but that the people who are supposed to take over for you when you're gone can actually get access to them. So I'd suggest that you make a list of the important passwords and put that list into the location list. I'm going to make sure that everybody has muted themselves so we don't have any more rings coming on. All right, so there's another section in the Red Book called the Final Instructions. And this is something that a lot of people don't really think about that much, and that is, what do they want to have people do for their funeral? Do they want to have an elaborate funeral or not? And that kind of thing. So people can actually give us their instructions or talk to us about their instructions, and we can actually type them up and prepare them for their red books if they want to, even as part of their annual or biannual update. So it's important to make sure that that's available. All right, Mari, can you mute yourself? All right, so anyway, the important thing is that to remember that these instructions are not going to be binding on anybody, and sometimes people worry about whether people are going to follow their instructions. But if you give the instructions, if you make arrangements with the funeral director and you give your instructions for what you want to have happen in the funeral, those instructions are, particularly with regard to the disposition of your body, those instructions are going to be binding. So that's important to consider as part of what you want to make sure happens. And the interesting, not really interesting thing, but the key thing to realize is that those instructions are going to get carried out often days or weeks before any estate settlement process begins with us. So it's important to make sure that those instructions are available if you have them, or that at least you've talked to people about what you want to have happen, so that your instructions can be carried out. Consolidating investments, and this is something that we often do when people do their initial funding with us. Oftentimes people come to us with 4 or 5 different brokerage accounts, or 3 or 4, and those can be very difficult for estate settlement purposes. So unless there is a really good reason to have the 3 or 4 separate brokerage accounts, we recommend that they be consolidated with one brokerage house. So if you have, one at Fidelity, and one at Morgan Stanley, and one at various different other places, we're going to recommend that you consolidate your investments in one brokerage house. So that makes it a lot easier and smoother for people to get the estate settlement work done. Now, attacking clutter is very important. I know that in my attic, I have lots of things that I need to make sure are appropriately arranged, so that when something happens to me, the people I leave behind aren't going to have a big mess to worry about and try to figure out what to do with it. So I'm sure everybody, if you have an attic, you probably have a lot of stuff stored in it. Make sure that you take a look at that clutter and see that it's appropriately disposed of or arranged for. Another thing is the special stuff list, or Tangible Personal Property Memorandum. That's TPP for short. And everybody has some blank TPP memos in their red book. We recommend that if there's something special that you want to give to a person, that you put it into a memorandum and have it witnessed. Your trusts say that if there is a memorandum, your trustee is supposed to follow it unless the state law they're operating under doesn't allow them to. So those are instructions that are important to follow. Bob, I just saw that you had a chat comment. Would you want to chime in with ask a question or say something?
I just went through this with my father when he passed away, and he had a trust and whatnot like that. But working with the banks, the broker, life insurance companies, they're all in some way very difficult to get cooperation, and they acted like they had never seen the process before getting the money out of them by the beneficiary.
Yeah, well, that's partly a function of funding. It's partly a function of how the trusts are set up, and when you have complete access to all of the funding information and you have written authorizations from people when you get started with the funding process, it does make it a lot easier to get the money out of them, I will say. Okay. So attacking clutter, make sure that if there's something special you want to give to somebody, I usually give the example of my own guitar, that I want to make sure that it gets to the right person. That should go in those TPP memos. Also, it's important to keep us up and current with who your helpers and your beneficiaries are. In other words, what their contact information is, and make sure that's current at all times, because it can make it very difficult for us to get in touch with them when something has to be done. And in addition, I've noticed that there are some people who have not necessarily updated email addresses, so we are getting some bounce backs on emails that go out. So make sure that we have your correct email address, so that you can get the regular newsletters and can get alerted on various different things that are going to happen. I just mentioned newsletters. I think I should probably mention this now, that we're thinking of doing a newsletter periodically that will be in a different format that allows people to have more access to various different resources and that kind of thing, and reminds people what they can do, makes announcements, etc. So that's upcoming. So for continuing with the lifetime steps, make sure that your helpers and your beneficiaries get the proactive training, and there's a lot more helpers and beneficiaries coming on this year than we've ever had before. They should be going to trustee beneficiary training, and we're setting up some grieving training this year. There's a lot of things that happen emotionally to helpers and beneficiaries when someone that they love dies. Most people don't realize this, but when a loved one dies, your whole life has changed. Everything is completely brand new. You may not think about that very much, but everything changes. And the effect of their estate plans can have profound effects on an individual's life. So there is a regular process that people go through in terms of grieving. Last month at the overview, we talked about the werewolf story, which has to do with surviving spouses normally, but it can be other people as well. So I would recommend that people go to the overview, listen to the werewolf story, so you understand the importance of anticipating that there is going to be some grieving, and that you need to make sure that you're prepared. So for trustee training, we do have some goals. We want to make sure that you know the law firm name and have our contact information. We want you to remember that there is a process. There's a regular process, and I'll explain what that is. It's the process that produces the results. It's the process that makes things go smoothly, so we want you to follow it. We also want to give you an idea of the types of issues that you're going to confront and that you're going to have to deal with as time goes by in that process. That's because it's important for people to be prepared and anticipate, so that their expectations don't get disappointed. And also we encourage you to take an interest in the planning that the client who's associated with you has done, because we recommend to our clients that they actually involve their beneficiaries and helpers in participating in their planning, so that everybody is on the same page. So there's several different key concepts. There's something called the smooth transfer template, which I'll discuss with you. The Heritage Design Transfer Process Navigator, the Settlement Commitment Clarifier, and the Settlement Coordination Plan. So I'm going to show you now the website, because we have a lot of that stuff on the website. So if you go to our own website, and that's heritagedesignlaw.com, on that page, if you scroll down on the right-hand side, you'll see a client sign-in button, and that will take you to client sign-in, which is right here. So in order to sign in, everybody that's in the Step 2 program and their helpers signs in. Their username is step 2. Note that there's a space in the middle. And the password is member with a capital M. And so if you log in, that brings you to this page. And this is the Step 2 Program Resource Center. So a lot of the things that we're going to be talking about today are located here. So let's see, where was I? Okay, so let's talk about the transfer process a little bit. There is the smooth transfer template will be on the website. I don't have it with me at the moment, but essentially what it does is it's a 2-column single-page item that describes the various different roles and actions that people should take who are clients or helpers on one side, and it talks about the things that we do on the other side with regard to specific issues. So what to do before the process begins, what not to do before the process begins. Various different things that we do. So that will be on the website and you'll be able to download it. I do recommend that you go on the website so that you can see that. The Transfer Process Navigator is on the website. Let me show you that. And that's right here under Estate Settlement. And there's two types. There's one for taxable estate and one for non-taxable estate. So I'm going to open the one for the taxable estate, and you'll see that it opens up a new tab, and here you get the diagram. So what's important to realize is that once you've been notified that something has happened, everything is supposed to stop. We don't want people taking action immediately. There needs to be some time that you take before you really start taking actions. So a lot of people can end up getting in trouble if they start closing accounts, or if they'll get a call from the broker saying that there's a retirement account here for you. What do you want me to do with it? Oh, send me a check. Well, before you do that, you have to realize that you may be sacrificing large amounts of benefits that could be obtained by taking precipitate action before you actually sit down and we can actually have a chance to talk to things. Another thing that that people generally end up with is common concerns. So we have a common concerns memo here, and that looks like this. And so, you know, that it's basically some Q&A. So what do I need to do immediately? How many death certificates do I need? These are very common issues. What should I do with any Social Security checks that arrive? Things like that are going to happen before we actually get going in our process, which will probably take about, you know, maybe in the first few days and first few weeks. Should I get appraisals of any of the assets? Well, no, just until we actually get going with our process, it's not necessary to get that started. Don't be dividing any personal property. There's a lot of do's and don'ts. So let's make sure that those things are very clear. And then another one is what to do when a client passes away. And these are the do's and don'ts that I was mentioning. So for example, call the law firm immediately, know where the red portfolio or red book is located, but don't remove anything. Just leave everything in it, because you're going to bring that to the first meeting. If there's any instructions for final arrangements in the red portfolio, be sure to review those. Arrange for care of pets, secure the house, things like that. But there are a bunch of things not to do. So don't close any bank accounts and don't roll over any IRAs. That's one of the top things not to do. Don't endorse any checks or other documents in the decedent's name. If you have a power of attorney, your power of attorney has just expired. All powers of attorney that a person gives expire when they die. Don't drive the decedent's car because we won't know whether there's any insurance on it. Don't remove any household furnishings. People can get very upset when things disappear. Don't pay any bills. Ask for 2 to 4 weeks extension on funeral expenses. And I would say funeral directors are very, very helpful on that. Don't use any of the decedent's credit cards. Don't contact life insurance companies. That's just going to get things very confused. We have a regular way of proceeding with collecting life insurance proceeds. And don't contact the banks or investment companies, because they're just going to say they don't have any authority to talk to you until they actually get the documentation and paperwork that they need that authorizes them to actually talk to you. Again, don't use that power of attorney. Make sure that you make lists of questions that you might have during the first settlement meeting. and read carefully any correspondence that you receive from the law firm. So that's what we mean. Stop. Don't do any of those things, because in the next couple of days or 2 weeks we're going to have a settlement counseling session. That's this one right here. So the settlement counseling session is really the first session. It's where we get organized for the whole process. It's got a fairly comprehensive agenda, and we're going to be going over all the various different steps that need to happen. We'll be allocating responsibilities between people and helpers, who's going to do what. We'll talk about the various different steps and the various different phases of the process, and we'll be having a lot of different activities like that. So the settlement commitment clarifier is another one of those documents like the smooth transfer template that we will have up on the website. But what it does is it clarifies who has what jobs and what our various different commitments to the process are. So then there's the settlement coordination plan, and this is a very important one. That first meeting occurs, and we talk about what's going to happen, and essentially the various different steps have to be coordinated and have to be scheduled. A lot of times what we do in that first part of the process is we have regularly scheduled telephone calls. So again, to start the process when somebody dies, call us, ask us anything you need to do to receive initial guidance. You can go to the website if you want to and download information, and follow the Heritage Design Transfer Process Navigator from there. So how do we prepare for the settlement counseling session? That's that first meeting. Well, review the Common Concerns memo, and the full trust settlement instructions. We have a fairly comprehensive set of settlement instructions. We usually put them in a book for you so that you can have them with you. It's a kind of a notebook so that you can store your papers relating to the settlement process in it. But review the Common Concerns memo, because those are things that we're going to be talking about, and then we'll be giving you a full set of instructions. And that document that I showed you about what to do when a loved one passes away, make sure that you review that too. So the settlement counseling session, that's where we're going to review the navigator, and there's one for the taxable estate. There's an extra step in the taxable estate navigator, and one for the non-taxable estate. The extra step is actually filing this one right here, filing the estate tax returns. We're going to review the commitments and the settlement coordination plan to make sure that everybody's on the same page. We're going to build a to-do list right there, and there will be regular to-do lists as time goes by. And we're going to review the estate plan. There is a design template that essentially describes what everybody's plan looks like. This is the way that we design people's plan with them at the beginning, and we have in recent years taken to putting a copy of the design template or a modern version of it in our clients' red books. And clients, if you don't see the design template in your red book, please let us know and we'll be sure to get one for you. Everybody's design template, by the way, is different, so it's important to make sure that yours is up to date. So those are the various different types of things we're going to be doing. We're also going to be talking about cash flow, because cash flow is often a very important part of the process, particularly for a surviving spouse. Having your spouse die, of course, is very disruptive in terms of how your finances can work, particularly if your spouse is the one that handles most of the financing. So, cash flow is very important, and we need to talk about when the money's needed and how much is needed and how we're going to make sure that we get it. We want to verify the assets. During the Step 2 program, we are annually updating everybody's list of assets with their how they're titled and what the values of the assets are, but that's just a snapshot on an annual basis. And when someone actually dies, we have various different things that actually occur as of the date of death. So we may need to verify what the items are, how they're titled, all the details of all the accounts, and what their values are. So that begins taking place at the settlement counseling session. And then we're going to be obtaining some signatures. So I mentioned earlier that, for example, when you're trying to deal with insurance companies and brokerage houses, they need to have paperwork. Well, there's affidavits the trustees sign to accept their trusteeship. There's authorizations the trustees sign to allow the brokers, broker-dealers and insurance companies to talk to us, because often that's what we need to do. There is, of course, a service agreement that gets signed at that meeting, and I should mention that we do have, and I'll talk a little bit more about it later. We do have an agreement with all of our clients about what the fee is for services in estate settlement, but it's not necessary for no one is required to hire us, is what I'm trying to get to here. Our helpers should understand that although we have an agreement with the clients about what we are going to do for them, the helpers and successor trustees and other people who are involved are not required to use us. It's often generally to their great advantage to do so, but I just want to make that clear. And then the first valuation teleconference is scheduled. So, for example, if you look at this, after the settlement counseling session, the valuation process begins. Now, what that means is, for example, if you have a brokerage account with a lot of different securities in it, you have to go to the brokerage house and ask them to give us the values of all of those securities as of the date of death for estate tax purposes. And valuing securities, particularly publicly traded securities, as of the date of death is a little bit more complicated than just getting the closing price. They have to do the average of the high and low selling prices for that day, and so we generally ask the brokerage houses to put that together for us if there's large sets of holdings. And so what we do is we schedule that next teleconference, because we'll be talking, the first aspect of what we're going to be doing is actually getting the value of all of the assets, making sure that we are very familiar with what those values are. So that's what that's the first thing we do at the settlement counseling session, or the last thing. Okay, so during that property transfer, during that process, that's this stage here, the valuation process in the teleconference reporting system, we generally set up teleconferences at least every month, sometimes quicker, sometimes more often, so that we can check back in, talk about what progress is being made on outstanding items, add additional items, check off items that are completed to make sure that we are moving along in the process, getting all the information that we need in order to go to the next stage of the process. So, part of our job is to provide valuation support. If there's real estate, for example, we'll get the appraiser to provide an appraisal for the property, and we'll talk to the appraiser about the specifics of what we're looking for. And we'll be preparing a complete inventory of the estate, what's in the estate. And the inventory will include the specific details of everything, as well as all the values. And that brings us to the transition strategy meeting, or transition talk. That's where, let me just flip back to the design. That's where we actually start talking about, okay, where do we go from here? We now know what we have, we know what it's worth. Do we have a taxable estate? Do we not have a taxable estate? If we don't have a taxable estate, then we're going to start setting up. We have to pay bills and expenses, but then we're going to be starting to set up the next step, or the subtrusts, and I'll talk a little bit about what that is, so that the instructions that our client is given can be carried out and we'll talk about how that's going to be carried out. In the taxable estate, that transition strategy meeting is going to be talking about how are we going to report the assets for estate tax purposes, what are the implications of that, if there's a tax, how are we going to provide for the sufficient funds to pay it, because the estate tax, even if we haven't filed an estate tax return, which can be on extension, has to be paid within 9 months after the date of death. So we try to make sure that things move along fairly quickly. Notice that we're talking about 6 to 9 weeks here, not 6 to 9 months. And so once we've got all that valuation information, we can then move on to preparing the estate tax return. And of course, we'll also talk about the next steps and what our strategy is going to be once we have the return. But the filing forum is when we file the estate tax return, and that generally involves a bunch of different people, including the accountant, including us, the trustees, gathering information, making sure everything is ready to sign and file the return. And so once that return is filed, we have to wait a little while for either the Commonwealth of Massachusetts or IRS to give us a closing letter. Most estates now will not be filing federal returns because, for example, this year the federal exemption is $5,430,000, and that's going up every year by the rate of inflation. But Massachusetts has an estate tax if someone has $1 more than $1 million, and everything is taxed from $1. So many estates are going to be filing a Massachusetts estate tax unless they have less than $1 million, even if there's no taxable estate, because we've set it up for marital deduction. If a person is married, you still might have to file a return. So once we've gotten through that aspect of it, once we've got the closing letter back, our next part of our process is to have a meeting about our long-term trusts. So generally, our clients have instructed us in their estate plans to set up trusts for their beneficiaries over their lifetimes. And it's important for the beneficiaries to understand the flexibility and the benefit to them, of course, which we'll be talking about in another session. But we'll be talking about how those trusts are going to be set up, how they're going to be funded, and then that again is a process where we have a regular reporting system on a regular monthly basis to set things up, because there are a bunch of different steps that occur. And once those steps are taken and the trusts are set up, then it's time for us to provide administrative support to the trustees. So what can happen after that, once the trusts are set up, is that things do change, things move along. There are a lot of things that happen in the lifetime of a long-term trust or a lifetime trust, and so we offer a Step 2 program for trustees, much on the same terms as a Step 2 program for our clients, so that they can be kept up to date. We can provide them with support, review their assets to make sure that things are held correctly, and we can make sure that red check review is to review everything to make sure that the assets are held properly. So here's a diagram of what happens in a married couple when the first spouse dies. We'll get to a single individual in a minute. But when a married couple dies, we have the Survivors Revocable Living Trust. That's what RLT stands for, and we have the Deceased Revocable Living Trust. And what happens is the trust automatically becomes an administrative trust. So what happens is we get a tax ID number, and when the initial settlement meeting occurs, we have the successive trustees sign affidavits accepting the trusteeship and setting forth specific information that has to be provided to the various different institutions, etc. And so that's when the administrative trust starts. It's very much like doing an estate settlement in the probate, but there's no probate. At least we're trying to avoid any probate. So, and that's why we have fully funded trusts, so we don't have to go to probate. So the administrative trust occurs, and that is in existence while we are doing the administration of the estate settlement. So that's the primary context in which we're working together as the helpers and as the attorneys to do estate settlement. And then once the administrative trust has finished, if there's a surviving spouse, we will typically establish the family trust, which is a trust for the surviving spouse and other beneficiaries, and to the extent that we would otherwise have a taxable estate, we will typically set up the marital trust. So the marital trust is there because it provides us with the marital deduction, and that means that there's no estate tax when the first spouse dies. So what happens on the second spouse's death? Well, again, we have the survivor's revocable living trust, and the survivor's trust also becomes an administrative trust for estate settlement while they're alive. And at this point, the marital trust and the family trust are going to terminate, because that's the date upon which they do terminate, and the successor trusts for the individual beneficiaries get set up. So here we show the surviving's trust. We have an administrative trust for estate settlement purposes during that period of time that we talked about, and then we have the beneficiaries' irrevocable trusts. Each of the beneficiaries' trusts are irrevocable because the only person who has the ability to modify them or revoke them is the trust maker. So that's what we do. So now we end up with the first spouse's trust breaks up into beneficiaries' irrevocable trust, and typically on the second spouse's death, their trusts look very much the same as the first spouse's. So we end up here with 6 trusts. Well, we don't want 6 trusts, and since the trust terms are generally pretty much the same, the trustees are pretty much the same, we merge them. So we end up with only 3 trusts in this case. So what happens on a single person's estate settlement? Again, we have the deceased RLT. We have we have the administrative trust, again, which occurs under Article 6 of everybody's trust. We establish bank accounts in the name of the administrative trustees. We get a tax ID number. We start collecting and gathering all the assets in the name of the administrative trust, and we do that for all of the estate settlements. And everything gets titled in the name of the administrative trust so that we can then control and dispose of it. And then when that trust is finished, when the estate taxes are paid and all the bills and expenses are paid, then the administrative trust terminates, and the trusts for the successive beneficiaries get established. And all of that, that last part occurs during this process here at the bottom. All right, so the property transfer and valuation process. So this is part of the administrative trust, and this is after we have gathered all the information and we have a general idea where we're headed. The first part of this is we get the red book and we start pruning it because there's things in there that just don't belong there anymore, and that we're preparing it for the use by the successor trustees. We have the survivor support program. So if you're a survivor of a person who's been a client, part of what we want to do is make sure that you are supported during the period of administration. And then after that, we have a maintenance program for you, particularly if you're a trustee or a beneficiary of a long-term trust. Those long-term trusts become taxpayers, and so it's important for initially to review the tax returns, make sure that people understand when returns are due by the trustees, what the various different ins and outs of that are, and how that works. We talk about for the beneficiaries' purposes, when they have access to principal, when they get distributions, how that all takes place, how the cash flow is going to be managed. And in many cases, we can help the survivor do their own strategic financial planning, particularly when there's a surviving spouse. We often need some help with that because things are so new. So when we've gone through that and we help the people with all that, that's when we get to the end of the estate settlement. And once we've gotten to the end of estate settlement, we then set up the long-term trusts, and we can provide support for the trustees on that. So some final thoughts and some wrap-up. The counseling issues. There's a bunch of different counseling issues that have to occur. Remember, in this whole process, there's valuation issues, particularly in the transition strategy meeting. There's a lot of ins and outs and questions that occur. How are we going to actually, what strategy are we going to use in terms of taxes, if there are any? What strategy are we going to use in terms of funding? What assets are we going to pick? Which ones are we going to liquidate? Which ones are the best to pass on to the successor trustees and make distributions to those from the administrative trust? There is a lot of different counseling issues that occur. Do we sell the house? Do we not sell the house? Does the surviving spouse want to move to a new place? We generally recommend that we hold off on that right away because there's too much disruption. I have some colleagues that actually try to delay things for a while because it takes a while for the survivors to kind of get accommodated to the whole situation, and you don't want to go too fast for them. And then there's the DOS analysis for beneficiaries. Let me sort of show you what that looks like. What happened to, there we go. That's the DOS analysis is on the website, and this is it right here. This is dangers, opportunities, and strengths for clients and beneficiaries. So, you know, DOS is a term that was developed by the inventor of the Strategic Coach program. It stands for dangers, opportunities, and strengths. That registered trademark is not the network's. So it's important to understand that everybody recognizes that there's going to be dangers, there's going to be some opportunities, and in order to get through those, we need to know what our strengths are. So there are a bunch of dangers. One is the lack of advanced preparation. Okay, failing to prepare in advance means that most people have poor sets of expectations and a settlement that just doesn't work very well. Being prepared in advance, understanding what's supposed to happen, who's supposed to do what, is really important in terms of preparation. The magic book mentality. Sometimes people think, okay, that red book is a magic book. It's all done. Everything's all taken care of. The magic book is going to settle the estate. Well, the magic book can't write letters, can't get up and move to banks and change accounts and all that other stuff. Really, estate settlement is about the activities of the people that they enter into when the estate is being settled. So, you know, we tell the snapshot story when we talk to our clients initially, and that is, you know, everybody has an idea of a snapshot of what's supposed to happen. So if you die and you're up in the clouds looking down, which is the best option, of course, instead of the other, and you're watching what people are doing, if people are doing what you expected them to do, then that's a plan that worked. If they're doing other things that are not what you expected them to do, that's a plan that didn't work, and that's unacceptable. So what we're trying to do is to make sure that everybody's prepared to know what they're supposed to do, so that snapshot that you have now actually gets carried out. Another one is low or no advanced communication with the client. It's really important for beneficiaries and successor trustees to understand what the client was trying to accomplish, what specific things that they had in mind. So we always recommend that our clients communicate what their thoughts are to their beneficiaries and successor trustees. Lack of attention to detail or failure to follow through. When every year we send out the funding update, it's in the blue books, and we have a regular part of the time during the year when people are supposed to fill out their funding updates. We have finished that section of this year, and I'm glad to say that we've gotten a swamp of them, which is very good. Our job is to make sure that our records are updated based on the actual details of everybody's accounts and their values that they report to us. Oftentimes people have new assets and need help to make sure that they're lined up with their instructions. But that's a lot of detail, and sometimes it's really easy not to pay attention to those. So the client's lack of attention to those details and the failure to follow through with the things that have to be actually done for funding can be a big problem, a big danger. A lack of interest and or commitment to planning. This is really not a characteristic of most of our clients, and we're very happy that that is true. But that can be true. People can gain interest or lose interest over time, and so we want to make sure that people do maintain their interest and their commitment to making sure their planning is going to work. And then there's the loss of the super competent client or homemaker. Particularly in a married couple, one spouse generally has responsibilities and another has other responsibilities. And when one of the spouses dies, we have this concept of the empty chair. So now there's an empty chair that's not being fulfilled, and part of the whole idea of preparing for estate settlement is anticipating that empty chair is going to be there. I have a colleague who, when he sets up the initial client meeting for the estate settlement, always makes sure that there is an extra chair in the room, and that's the empty chair for the client, so that everybody knows the client's there in spirit, even though they can't be there physically. So opportunities are, for beneficiaries, they can receive the assets in a protected way so that their creditors can't get to them, and there's a lot of advantages to that. The settlement process can give beneficiaries a head start on their own planning, and when we talk about the session in October, that is a major part of that. It's called wealth reception planning. It gives people the opportunity to reduce costs on transfer, both for fees and taxes, and it provides, there's an opportunity for current learning, the maintenance and education program, and there's an opportunity to capture the client's legacy, both their personal wealth and their stories, their who they are and that kind of thing. So there's a lot of different opportunities. So the big strengths are, for caring clients, and we're very happy to know that we have so many caring clients in our Step 2 program. Lots of advanced organizational work accomplished by the client, and over the last, I would say, almost 10 years, we've gone through quite a transition in our Step 2 program from the way it was before I left the law firm in Boston. And there's been a lot of changes in how the Step 2 program operates nationally. So in the national network, I'm a member of the national network. So, and everybody in the network does their planning pretty much the same way and operates a Step 2 program. So, the strength of having advanced organization accomplished by the client, we're very happy that our Step 2 clients have been so enthusiastic. Then there's a prearranged fee agreement available, which I'll go to in a minute. And, you know, a trusted relationship between the client and the firm that is very important to build on, because when you are doing estate settlement and you lose trust in the firm or in the people that you're working with, that can be a disaster. That's a plan that doesn't work. So, where was I? So let's, I want to review the website information. Again, this is, you go to heritagedesignlaw.com, you sign in using step 2, and note there's a space between step 2 and step and the 2. You use the password member, and so then you get to the website's resource page. So I just want to review what's here. Again, there's a lot of information about overview. There's a calendar of events. We have a page that shows you exactly how the whole year works as in general, how it's structured, the calendar of events, the annual client meeting registration form, our current Step 2 program member agreement. And this is the agreement that we have with our clients that shows, you know, what that talks about what we're supposed to do in the Step 2 program, what our commitments are, what our clients' commitments are, and also sets forth what our obligation is in terms of offering services for estate settlement. So it's important that people understand the fees, so I'm going to review the investment summary right now. And this is all of our clients have filled out an investment summary, and this is what it looks like. So the first part of it, excuse me, is about the initial settlement process, the initial design of the estate settlement, of the estate plan. So living trust, forward wills, living wills, etc. That talks about what the fee is. Then there's the maintenance and education program. In the first year, the fee is $995, and then there's an annual fee, which currently is $595. And then there's the survivor support system that I mentioned. So if you have a long-term trust, someone has died and you have inherited a long-term trust, the survivor support system also provides you with a maintenance program for you as a trustee and as a beneficiary. And that has an annual fee as well, which is comparable to the annual fee for the Step 2 program. It's currently $595. Not $495 as it says here. It's $595. Excuse me. Then we talk about the estate settlement services. And, you know, there's a settlement fee on disability, currently $995, and that's basically to help the successor trustees take control of the assets as the disability trustees. And then the death settlement, there's a fixed fee option and a variable fee option. We have not yet had any clients choose the variable fee option because it ends up being quite a bit more expensive. But the fixed fee option, these are the kinds of services that are offered in this for the fixed fee and during estate settlement. And the way it works is that the fee has a cap of 1.25% of the value of the assets at the time of death. Now that's a cap, that is not the fee, so the fee is going to be some amount underneath that. And this is our commitment to our clients about what the estate settlement is. Estate settlement cost is. Around the country, the estate settlement legal fees ends up averaging out about 2 to 3%. We think that we can do it for quite a bit less because, again, we have so much information. We have all of the funding information. All the documents are updated biannually. And the people that we're working with have been trained, or at least have been partially trained at some point so that, this is the kind of thing that we're able to reduce the fee on. Now, you'll note here that there is a 0.75% cap with step 2 involvement. And what that means is that by attending these estate settlement sessions and the other nuts and bolts programs, you end up, the helpers end up with a 0.5% discount on the cap. So that's a substantial reduction in what the fees are. There is a $6,000 minimum fee because there's certain things that we have to do. But within that structure, that's how we do it. If we're going to do the estate tax return preparation, that's an additional 0.5% or up to an additional 0.5% of the value of the assets. Traditionally, we haven't done the estate tax returns. We thought for a long time that giving the estate tax returns to the accountants was the most efficient way to do it. But more recently, we've discovered that the accountants are, in our view, overcharging for the services, and we still have to review the returns anyway, so we are taking on more estate tax returns ourselves. And we're also doing more gift tax returns as well for the same reason. These are the fees that this is the fee structure that we have set up, and this is the fee structure that we're generally going to stick to. But remember, I want to repeat that the client's helpers and beneficiaries are not required to hire us. You're certainly welcome to hire someone else. Typically, people do not hire someone else because it's very difficult to get someone else to tell you how much it's actually going to cost for them to settle your estate. And typically, as I say, the average, because other people don't know what you've got and don't know whether your documents are up to date, and they tend to do a lot more work. We're able to have the helpers actually participate in the planning and the estate settlement, so it is a lot less expensive in our methodology. So again, we have 4 goals. We want our helpers to know our law firm name and our contact information. Remember that there's a process, and the process produces the results, so please follow it. We wanted to give you an idea of the types of issues that you'll be dealing with in the estate settlement process, and we want to encourage an interest in the planning participation. So 911, this is the emergency has happened. Here's what we'd like you to do. Call the law firm. That's the first thing. Second thing is to locate the client's Blue Book. The Blue Book is the basic operating manual for the Step 2 program. All of our clients have one, which they bring to the annual client meetings. And then locate the client's Red Book, which is where all the documents are, where the location list is. That's the key thing to find, and then relax. Remember, there's a dependable process that you can follow, and we're here to make sure that you can get through the process with as little aggravation as possible. So how do we get the whole family to participate? There's the settlement fee incentive. There's disability health care discussions. We've already talked about the settlement fee and the incentive that's that 0.5% discount over the 1.25% cap for participating. And that's why we want to make sure that we have everybody participating. I should also mention that on the website, if you go to the website and you don't have to register with us now, because we have a record of who attended this this session. But if you attend a session, because they are recorded and we do upload them to the website, and you can see them on YouTube. If you attend a session, then make sure that you take the attendance confirmation. So what that is a very short questionnaire about things. Fill it out, send it back to us so that we know that you actually attended the program. So let me give you an example. here's the attendance confirmation for the last program that we had on disability, that we recorded anyway. So fill in your name, your email, and then answer these questions. And please give us any comments that you have on the program. Just a few questions to discuss the high points in the session. Healthcare discussions are really important. We can prepare healthcare proxies, and we can prepare a healthcare power of attorney for people when they're in the hospital to have someone be their advocate. But if the client doesn't talk to the people who are actually going to be carrying out what their instructions are, they don't actually talk to them about what they want and give them instructions, then they don't really know what they're supposed to do. I've told this story before. There was a case I read about last year where an individual had given some very detailed instructions about what he wanted to have happen if something happened in terms of his healthcare treatment. And then he started having, he had an accident, he started having breathing troubles. He ended up having a breathing mechanism and feeding tubes, went through a long period of time when he was having a difficult time as a patient, and ultimately died. And it wasn't until after he died that they discovered the instructions in his file, both in the medical file and in his home file. And his son, who was supposed to carry out the instructions, found that his father really didn't want any of that to happen. He wanted to die peacefully and in dignity, and he didn't want to have to go through all of that misery. So that was disappointing. So it's really important that all of those conversations occur. We can do all the documentation we want, but the documentation that we do really doesn't take the place of having an individual conversation with your healthcare proxy, with the people that are going to be taking care of you during disability, particularly for those end-of-life decisions. And then another aspect is the wealth reception planning, and there will be a session in October. Let me show you the calendar for this year. Oops. In October, here's the calendar. Our first annual client meeting, by the way, is May 25th. Our next session, our next nuts and bolts section, is September 13th. That's nuts and bolts of disability, and that's for members and helpers. And then the final session of our education program this year is on October 4th, and that is nuts and bolts maximizing your inheritance. And that's for members and helpers, but primarily for helpers and beneficiaries. It talks about all the various different things that you can do to maximize the benefit of the planning that's been done by our clients so that you can enjoy the benefits the most, the way it was intended. So the settlement fee incentive is done. Nuts and bolts for disability, September 13th. Maximizing your inheritance is on October 4th. Please put those in your calendars. One other thing that I want to show you on the website is to make sure that you have registered with us. And what you do is you go to the website, and at the bottom of the resource page is this questionnaire. Just fill it out. Don't use the name step 2. Use your own name. Give us your email address. Confirm your email address and give us your telephone number, and identify what client that you're related to, and any other comments or questions you may have. That goes to us. If you fill that out and finalize it and say send, we get an email with all of that information, and we'll put you into our mailing list. So let me call for questions. I'm going to make sure that nobody is involuntarily muted. it's time for any questions that anybody might want to ask right now. So feel free to ask.
Frank, I'll start.
Okay.
So earlier you had mentioned that some things should be handled in a personal conversation with somebody, as opposed to trying to have someone decipher what the red or blue books are all about, correct?
Well, what I was talking about there was your healthcare desires, your desires about healthcare decisions.
So in addition to healthcare desires, there's always, personal things that don't show up in the red book, or things that didn't get updated in the red book that we had modified. So do you recommend updating the red book once every year, or do you have like a personal list for your clients to say, okay, it didn't make it in the red book, but here's some initial direction that I'm giving to my loved ones?
Well, there's always things that you can talk to your loved ones about that you want to make sure they understand and that they're going to do. If there's specific legal things that are involved in what your instructions are, please make sure that you've told us about them so we can decide whether you need to have an amendment to your trust if it's an off year for you, if it's not your update year, or we make sure that they get into the update for the update year. So that would be if you're having an update year and everybody's in 1 year or another, it's every other year, you will have, when you come to the annual client meeting, in your blue book, we will give you an estate planning review worksheet. And that's supposed to be due by, I forget what the date is, but it's in July, so that you can tell us what changes you want in your plan. And we can, if there's things that we need to ask you questions about, we'll get in touch with you. But if you think of anything during the year that you want to have changed, you want to change somebody's role, or you want to add some instructions to something, please feel free to call me. Remember, we have that first call right. We want to make sure that you call us first before you make a mistake or leave anything out.
Yeah.
So please feel free to call us if you have any questions about what should or should not be changed in the documents and the kinds of questions and instructions that you should be talking to individuals about.
That's good. Now, is there a particular dollar amount value that you would, either use as a threshold, something that's over $500, make the call to you, or anything under $500 bucks, it doesn't really matter?
You mean you're talking about specific bequests?
Yeah, request to say, assets, or you have a son or daughter that you want to leave something to, but it's small, insignificant, but there is some value to it. Is it a threshold you typically?
No, there is no threshold. Those things should be in your documents.
Okay.
Okay.
I mean, for example,
the problem is that if you're asking your trustees to do something that is not in the documents, they're violating their fiduciary duty to uphold what it says in the documents. Even if they've talked to you, they're supposed to follow what's in the documents. So, because they could be criticized by other people for having done something other than what's in the documents. So it's really important to make sure the documents are updated correctly.
So we didn't really dial into the, small insignificant stuff like clothes, photo albums,
Well, those kinds of things should go into your TPP memos.
Okay.
That's that personal property memorandum that's in the back of your red book. It's a blank form.
Okay.
Okay, so you should take a look at that. Particularly personal property, those are the kinds of things that should go in there because the trustee can follow those.
Okay. That I wasn't aware of. I apologize for that. Thank you.
All right. Any other questions? Well, okay. Remember, if you have any questions that have come up about this, feel free to give me a call. Remember, the meter's not on. Whether you're a helper or whether you're a client, feel free. 617-630-5700, extension 1 is the number. And we look forward to hearing from you. And assuming that there's no more questions today, I'm going to finish the session and thank you all very much for attending.
Thank you.